Hey gang, criminal defense attorney Ryan Pacyga here, and today I'm going to talk to you about what aiding and abetting or liability for crimes of another is. And we're going to talk about Minnesota law, though a lot of states are pretty much this way for aiding and abetting crimes. And what that means is that the defendant, meaning someone charged with aiding and abetting a crime, is guilty of the actual crime that was committed by someone else if the defendant played an intentional role in aiding the commission of that crime and made no reasonable effort to prevent the crime before it was committed. So, an intentional role is defined in Minnesota, and it means things like intentionally aiding, advising, hiring, counseling, conspiring with, or procuring another person or persons to commit the crime. So the defendant's presence or actions constitute intentionally aiding only if first the defendant, and when I say the defendant in this video, I mean you if you're charged with aiding and abetting, you knew that another person or other people were going to commit or were committing a crime. Second, that you intended that your presence or actions aid in the commission of that crime. So it doesn't just mean being there without doing anything. That wouldn't be aiding. It's got to be more than that. So what the jury instruction says, or what's giving to jurors when they deliberate on this thing, it said if the defendant aided another person or persons in committing a crime or intentionally aided, advised, conspired, like I told you before, the defendant is also guilty of any other crime that the person or persons committed while trying to commit the intended crime, if that other crime was reasonably foreseeable to the defendant as a probable consequence of trying to commit the intended crime. What does all that mean? Let me give you an example. Let's say that you and your friends decide that someone's going to hold up a gas station attendant and try to rob money out of the register. And maybe you're going to be the lookout, like you're standing outside the doors of the gas station to make sure police or other people don't come, right? And that's your only role in it. And maybe even it was an agreement that if things got heated in the store, nobody was going to shoot, right? Well, so one of your friends or a couple of your buddies go inside and they pull out their guns and they hold up the clerk at the gas station, and then something goes wrong, and instead of just robbing it for the money, one of your friends shoots the gas station attendant and kills him. What the law says for aiding and abetting is, first of all, you're not just there, right? You're aiding in the commission of that crime in that scenario because you're looking out. You're helping these guys inside do their job of robbing the place by looking out for them and being an alert for them if either the police or someone else is going to be coming into the store that could disrupt the robbery. So you're aiding in the commission of that crime already. But what this part that I just read to you says is that you'll also be responsible for what's called a felony murder here, because it's reasonably foreseeable that when someone goes in with a loaded gun to rob a convenience store, that something could go wrong and that they could shoot the teller at the register there that's maybe resisting the robbery. That's reasonably foreseeable, or at least that's what the prosecution would argue, that you're responsible for aiding a murder, even though you had said, hey, I thought this was just going to be a robbery. So that's how the law can work there. But what the law also says is that the defendant is guilty of a crime only if the other people committed that crime. The defendant is not guilty for intentionally aiding the commission of that crime unless the crime was actually committed. So let me give you an alternative on this fact scenario I gave you. Let's say that you make an agreement that they're going to rob the teller again at this convenience store. But the people go in and they get into an argument and they never pull out guns, and they leave, right? And they don't get any money. You can't be guilty of aiding a robbery in that situation because there was no force used inside of the gas station that would make it a robbery. Robbery involves the use of force or threatened force in order to take something from someone. So if an argument happens but they don't threaten that person, they don't pull out their guns, they don't take any money, then that's not a robbery, and then you can't be guilty of aiding and abetting a robbery because no crime was actually committed. At least the crime of robbery was not committed there. So that's how that can work, okay? Now, here's the sticky part. Sometimes someone who's not charged as a principal, meaning the main person can still be guilty of aiding and abetting. And what the law says there is that the defendant is guilty of a crime committed by another person if the defendant played an intentional role in aiding the commission of that crime and it made no reasonable effort to prevent the crime before it was committed. So what does a reasonable effort of preventing the crime? Well, you could get in the middle of that and say, hey, you know what? This is off, guys. I'm not going to look out before they pull out their guns. I'm going to get out of here. I'm not going to be a part of this. I'm trying to prevent you guys from doing this. I don't think this is a good idea. You should stop. And then you leave instead. You've got an argument that that was a reasonable effort to try to prevent the crime and that you didn't participate in it. That's just one example. You can think of a lot of examples here. Finally, the last part I want to let you know is effective withdrawal under our law in Minnesota. And it says that even if the defendant aided, advised, hired, counseled, or conspired with another, or otherwise procured the commission of the crime by another person, the defendant is not liable for any crime, including the intended crime, if the defendant abandoned the purpose and made a reasonable effort to prevent the crime before the crime was committed. Okay, so that's talking about the effect of withdrawal from that. It's kind of like a conspiracy law in a way. It kind of operates that way. So if you abandon the purpose and made a reasonable effort to prevent the crime before the crime was committed, then you could be found not guilty of aiding and abetting because of that attempted withdrawal. Now, here's one really weird twist in the law. I had a murder case once. It was aiding in a murder where a shootout happened outside of a bar. My client wasn't the guy with a gun. They go running, and later police claim that my client took the gun from the other guy and tried to throw it on a roof, and he aided in the murder that way because he was getting rid of the murder weapon, right? And that was part of the crime here to cover up the murder itself, right? Well, law enforcement lied about where they found the gun. We found that during the trial, but get this. The original shooter, that was my client's friend, he had a self-defense claim, right? And what the law says is if you're charged with aiding and abetting a crime, you can even be found guilty of aiding and abetting even if the other person is found not guilty of the crime, which is just crazy. Can you imagine someone's found not guilty of a murder because a jury actually finds they were properly acting in self-defense, but the prosecution has charged you with aiding in that murder, and in that case, you don't automatically win because this person was found not guilty. So what was really twisted in that situation is that the prosecutor actually put my client on trial first, knowing that this guy had a pretty decent self-defense claim, okay? And rather than seeing how that played out and then seeing if it would be just to even put my client on trial, he put him on trial instead, which was a pretty dirty thing to do. Anyway, we got him a not guilty verdict. We found it was a mistrial the first time. We go back to trial with a new jury. The police changed their testimony in that second trial bad, and I caught them in their lies, and fortunately our client was found not guilty of aiding and abetting murder in that situation. But that's a little bit about the aiding and abetting law. We've got some trials going on right now that have been reported on in the news, and I thought it might be good to just give you a little information about how aiding and abetting law can work in Minnesota. Of course, if you're charged with aiding and abetting, if you got any questions about that, you can always find me at arrestedmn.com or call me at 612-339-5844. Roam free.